Arunji,
Hi, good morning, all. I'm Arun Aggarwal, Executive Committee member, immediate past chairman of Gurugram branch of ICAI. I take this opportunity to welcome all of you to this webinar, wherein we are going to be discussing HR issues that have cropped up or might crop up due to the lockdown amidst the COVID-19 issue that India is facing. I take this opportunity to welcome Chairman Gurugram branch Dheeraj Sharma, Chairman Vapi branch Shyam Purohit ji, Chairman Agra branch Sharad Paliwal ji, and would like to thank all of you for making this kind of a webinar possible. We also have amongst us Shri R.K. Kedia ji, who's going to be the guest speaker for the day. Guys, this the topic today is pretty interesting because as soon as we started talking about a lockdown and businesses being closed for as long as a month and probably more, one of the things which is important is to make sure that the employees are happy. At the same point in time, to make sure that our cash flows are meeting, the requirements of the business as well as of our employees. And that's a time when government is requesting all the businesses to see how we can help the employees. So there are multiple issues that are gonna be there for us to tackle. For example, can I let my employees go, specifically those who are not working? If at all there is an employee who is gone, back home, not able to join post the lockdown, what's gonna happen? How does the new PF related benefits that government is sharing with the government has come up with? How do we take benefit of that? And I'm sure there'll be a lot more. To start the session, may I request CM Mohit Singhal, Secretary of Gurugram branch, to please take it forward.
thanks a lot, Arunji. A very warm good morning to everyone. Today we have two speakers. First one, I introduce Advocate R.K. Kedia ji, who is a HR professional with having more than 38 years of experience, with expertise in the field of formulation and execution of HR policy and system across India. Currently, he is working head of the labor compliance in Intero Solution. And on other side, we have with us CA Kapil Goyal ji, who is having more than 20 years of professional experience in his firm, including the multiple division of the MNC throughout the working in this compliance. I welcome both of you and directly hand over the mic to Mr. Kapil Goyal ji to start his deliberation.
Thank you, everybody. And thank you, Arunji, Mohitji, and Chairman Sirs of Agra branch as well as Vapi branch. So I would like to tell you that today we are sitting at such a time where the HR issues have been cropped up to a greater extent, and all of us, whether we are managing clients, whether we are chartered accountants, whether we are lawyers, whether we are operational guys managing the companies, everywhere this HR issue has become so predominant, so that everywhere the whole industry is looking at CAs, all our CAs, to give our valuable advice during this pandemic. So today we are going to touch base upon all practical issues, and today's seminar will be more practical oriented and will take all possible frequently asked questions by the employees, by the clients of our esteemed clients, industries. And today we will discuss among ourselves as to the what best replies we need to give, and what best action we need to take. So during this pandemic, I would say that there are some positive developments also for our chartered accountants brothers. As you all know, that India will be among the top 2 or 3 countries in the world which will be having a positive GDP growth in this year. Earlier, it was projected to be around 6.5%. Now, IMF has reduced it to 1.5%, around that level. So, this is the time where we all have to work together in collaboration, and to show the outside world that we chartered accountants are capable of taking over the best of the best companies in terms of financial advisory as well as HR advisory. because labor compliances, as you all know, we have earlier done one seminar at the branch level, Gurgaon branch level also. So we got a very good response on our labor compliances matters. So I would like to thank you once again. And in today's seminar, we will try to be as practical in our approach, which would benefit the entire community. So I would not take much of your time, and we will start the webinar now. And I will ask and request Mr. Kedia to take the dais and start the deliberation. Thank you.
Good morning, everyone. Thank you, Kapilji. Thanks for the introduction. Thanks for the organizers to invite us for this webinar today. And as you have rightly said, we are in a very peculiar situation where I think for the first time during our lifetime, or even in the lifetime of our parents and grandparents, this kind of opportunity would have come for the first time. Now, what exactly do we understand by lockdown? That is the basic idea. What is lockdown? We would have heard many things about other things: lockout, retrenchment, layoff, etc., curfew, and then let's say imposition of section 144 under IPC or section 144 in CRPC. What exactly do we mean by lockdown? So let us understand what lockdown is, and then we come to what issues we are facing as HR professionals or even as accounting professionals, and which are to be taken care of by us in the normal course of business. Lockdown, let us see what lockdown is. I'm repeating, it is not lockout, it is lockdown. And what do we understand by lockdown? Lockdown is an emergency measure or a condition in which people are temporarily prevented from entering or leaving a restricted area or building during a threat of danger. Now, this can be confined to a smaller place, or this can cover the entire geographical area, which has been done in our country, where our Honorable Prime Minister on 24th of March said that lockdown will be there in the entire country for a period of 21 days, and that got extended by another 19 days. So, total of 40 days in total. Now, having done that, what do we do under lockdown? How this lockdown came into picture? See, there is a act called Disaster Management Act that was passed in 2005, which carried forward some of the provisions of Epidemic Diseases Act 1897. Now, please try to understand, the earlier act was formulated in 1897, and after a lapse of almost 108 years, we have Disaster Management Act, which carries some of the provisions of Epidemic Diseases Act. It is out of these two, that is Epidemic Diseases Act and Disaster Management Act, that the central government has gone ahead and given certain guidelines or certain instructions or certain advisories that have been issued for the entire country. If at all you have had a chance of going through the advisories or the circulars issued by the Ministry of Home Affairs, you will come and see that in none of the advisories or in none of the instructions they have ever referred to the employer-employee relationship. It is a general advisory, but thereafter they have clarified what will apply to whom and how it will apply. So the directions have been given with the objective of curtailing the spread of disaster or epidemic, and therefore the directions which have been given to stop the after effects of disaster or ongoing effects of disaster and epidemic, they are binding not only on the individuals but all the entities that are existing in the country. Having taken care of this lockdown, let me briefly reflect upon what is curfew. In curfew, what happens is people are instructed to stay inside, and this is what certain states did. They imposed curfew and forced the people to stay inside when the essential services are also shut down. And whereas in the case of lockdown, what happens is the restrictions are there, restrictions are more on assembly because you know the epidemic or the pandemic which is there, that can go, that is contagious, and therefore to remove that contagious factor, it is seen that essential services are only made available, and people are allowed to roam around or allowed to move around, but not in batches. Here and there, one or two persons for the purpose of availing essential services, they can go. So in lockdown, while no pass otherwise is required, but keeping in view the pandemic, what has been done is the government has said that we will issue a pass and there will be not many exemptions, and mass gathering is prevented, and the violation can lead to legal action. That of course we will come in the subsequent slides which are there. So having understood the concept of lockdown, now what exactly are we supposed to do in the lockdown, that let us understand, because thereafter we will get into the legal provisions as well, what exactly is to be done, what not to be done, and what are the orders that have been issued by the various the state governments and the central government. So while we will be sharing the slideshow, the PPTs with you, there will be no problem. Let me get on to with the content and explain it to you. The first slide which we have, in that we have given the various orders that have been issued by either by ESI or the Provident Fund or the Ministry of Labor and Employment or the Ministry of Home Affairs. Now I'll take one by one. In the case of ESI, the ESI Corporation initially they said that a period of 30 days would be allowed as grace period for making the contributions under ESI. Subsequently, it has been made to 15th of May for the contribution which was falling due for the month of February. That is, what was to be paid on 15th of March in respect of wage month February, that has been allowed to be paid up to 15th of May. And for the month of March, what was to be paid on or by 15th of April, that can also be paid up to 15th of May. This is what the benefit or the relaxation that has been given by ESI. In respect of Provident Fund, only in respect of the payment which was to be made for the wage month March, they have allowed the payment to be made by May 2020. That is, the contribution which was to be paid by April 2020, that can be paid up to May 2020. To obviate the difficulties which are being faced by the employees or the employers in turn, the Provident Fund authorities have also given certain benefits by way of allowing refundable, non-refundable advance to be taken by the employees for next 3 months for those establishments that have up to 100 employees and 90% of whom they earn under rupees 15,000 as monthly wage. Now, this of course relaxation is there, but the reaction which I have been having with most of the clients and most of the other participants who are there, most of the other entities who are there, they have not found it to be of much use. And let us see if there any further relaxation would be there. So these are the things which Provident Fund authorities have done for the benefit of the employees. But now coming to the employers part, in case of the employers, while even before the lockdown came into picture, many of the state governments, they had gone ahead with their own notifications. For example, in Delhi, the government of NCT of Delhi had already closed down the establishments from somewhere near 19th of March, and saying that all the establishments of specified nature, they would be closed down up to 31st of March. But before the conclusion of that period of 31st March 2020 came the order from the Ministry of Home Affairs, which was under the Disaster Management Act, which superseded, I repeat the word, it superseded all other laws which were applicable in the country, so as to meet the contingencies that were being faced by the country due to this pandemic of COVID-19. Now, when these directions were issued, you will have to go through the Disaster Management Act, and Section 72 of that Act says the provisions of this Act. Please try to understand so that it will be very clear when you are putting up the questions for being answered. The Section 72 of this Act says the provisions of this Act shall have effect notwithstanding anything inconsistent therewith contained in any other law. Mark my words, it is in any other law for the time being in force, or in any instrument having effect by virtue of any law other than this Act. If you read it plainly and simply, please try to understand that this Section 72 is prevailing or taking precedence of on all other provisions of all other acts that are applicable to the country, particularly in the area of labor laws, because it is the human being which is getting affected by this pandemic, and therefore anything which has been prescribed under the law anywhere, whether it is the service law of any state or the central laws which are applicable to the labor, they all have been superseded by this Section 72. And under this, the first order that was issued after the announcement made by the Honorable Prime Minister on 24th of March is the first order that was issued on 25th of March, followed by 27th March order. Thereafter, an order was issued on 29th March that was followed by orders on 2nd of April, 4th of April, 10th of April, 14th of April, and 15th of April. Now, we will restrict our discussion only to 29th March circular for the present discussion. The 29th March circular that said that the employer will have to whatever be the type of establishment, they will have to pay the wages. They will have to pay the wages without any deduction on due date to all the employees, and therefore even if the business is not being able to run, you will have to pay the salary or wages. Of course, by virtue of, because after 29th March, the salary was payable for the wage month of 31st March, people, by some way or the other, they were able to pay. Many of them have even not paid, because if you would have read the various paper cuttings which are there, many of the organizations have not paid the wages or salaries even for the month of March. So what to talk of the period which will fall as lockdown period in the month of April. But then that was the guideline, and if you are not abiding by it, then the legal consequences will follow. So and subsequently, what has been done, what order we were speaking about, the lockdown period on 14th of April has been extended up to 3rd of May, that is for 19 days more subsequent to 14th of April. So total of 40 days of lockdown period is there. Now, how do we go ahead with it? So how to go ahead with it, Kapil ji slide को change करिए. These are the HR issues with CA firms and clients, and these will have to be looked into by the guidance which we have been given to the people. What is required to be done? See, there you will be having different kind of establishments with you as your clients. So it is not necessary that all the people or all the establishments will be able to frame work from home policies. So it has to be done only for those policies, for those functions where work from home can be done. For example, in the case of manufacturing companies, this will not be possible where you have to produce the goods or where you have to be on the shop floor. This may not be possible. But then wherever it is possible, please try to frame work from home policy. full salaries and statutory dues have to be paid for all the staff during the lockdown period, as has been mandated by the 29th March circular from Ministry of Home Affairs. The even during that lockdown, some of the manufacturing industries, some of the other offices, they were allowed in the category of being in under essential services category, and therefore they were allowed to function. For those establishments and industrial units, there were certain things or certain precautions that were required to be taken. These have to be followed. The precautions have been outlined by the Ministry of Health as well as Ministry of Home Affairs, and those guidelines need to be followed for if you are opening your establishment or you are operating your establishment during the period of lockdown. So these are the precautions that need to be taken not only for the betterment of the workers who are coming or the employees who are coming, it is for the betterment of the establishment in itself, so that pandemic or the contagious effect of COVID-19 is not there. Next slide, please.
Yeah, in this, I would also like to add one point which has been released today by Ministry of Labor and Employment. So they have launched a website for the workers' grievances to be put up there, and the Ministry of Labor and Employment will take all necessary actions against the grievances of the laborers and the employees. So it is in our interest to take care of all the employees during this lockdown, and we must give them all the answers. All their grievances must be addressed properly, so that there is no negative or notice issued by the labor department on the response of the workers grievances. So we need to take care that now in the today's world everything is online, so anybody can go and on the online and mark their problems, which can create issues with the employers, be it CA firms or be it our clients.
So, continuing from where Kapil has said, so how do we tackle with the the issues which are there, or because employees are there, they will have their own grievances, they will have their own issues. What exactly should be done? Now, HR, it is not necessary that when we are saying that these are the HR issues, it is not necessary that it has to be dealt only by the HR people. After all, we are all human beings, and all these issues, they come along with the human beings who are working in the establishment or the factory. So, what do we do there? Now, to take certain precautions or to take certain steps which are beneficial for the employees, what we should do, we should have a single point of contact to reply on HR lockdown matters. But before doing that, all these issues which are arising in our establishment, they should be uh, discussed with all the partners or all the stakeholders who are there in the company or the firm. You should have a unified approach, and that should be made aware to the HR staff who is going to interact with the people. But I make it clear, there should be only one point communication system. Otherwise, what will happen, you will have various kind of things which are coming out from the management's point of view, not only creating confusion in the minds of others, but it will create complications for the management when there is any kind of inspection or any kind of inquiry which is coming from labor office or from the government authorities, that will make your things impossible to be handled properly. So what we say is all these issues should be dealt with strictly on merit. You should have a unified approach in what you are going to convey to the employees, and thereafter only convey to what has been said there. Now, post lockdown, what happens? Once the lockdown period will be over, what is going to be done or what needs to be done? There, we will have to see that you will have to, because you will be facing the difficulty of less revenue, you would be facing of the possibility of cancellation of orders. The people who would have paid their dues by way of post-dated checks, that must have also got stopped, because they are also facing the difficult situation as far as their revenues are concerned, and therefore the payments are concerned. Similarly, you will also face the same kind of difficulty, And for as far as you are concerned, vis-a-vis you, your clients or customers would also be facing the same difficulty. So this is how it is going to happen, and this will be a chain reaction. So what you should do so as to see that you are at ease when you start your operations in full scale once again after the period of lockdown. As far as HR issues are concerned, you will have to see whether your appointment letters are there. The appointment letters may require a review. You may have to see whether you want to lay off the people, you want to retrench the people, or to the worst of the possible scenario, you may have to close down the undertaking because you don't have the orders or you don't have the financial position where you can carry on with the organization. In that case, depending on the strength of workmen, there will be various issues under the Industrial Disputes Act which you will have to take care of. But I don't think that should be resorted to. Closure is never an idea of the entrepreneur, and he would definitely like to see that his establishment keeps on running, even though there might be various difficulties which needs to be overcome. So, and while, as I said, you will have to review the appointment letters, etc., your Industrial Employment Standing Orders Act. Why I am referring to Industrial Employment Standing Orders Act is because Government of Haryana has made the Industrial Employment Standing Orders Act applicable to shops and commercial establishments which are operating in Haryana. Therefore, it is necessary that we have an idea of what Industrial Employment Standing Orders Act is, which will govern the terms and conditions of employment under the Shops and Commercial Establishment Act. So these will have to be seen. You will have to differentiate between a probationer and a confirmed employee, whether you would like to carry on with the probationers, whether you would like to see whether the some of the confirmed employees may have to be, asked to go away. All these things will have to be looked into. The contractual manpower will have to be rationalized. If you don't have those many orders and you don't require that kind of manpower, therefore you will have to review all these things. But then a concerted action will have to be taken by all concerned who are there in the establishment in the body of decision making. Having said so, these are the post-lockdown measures which you will have to take. But then how do you do it? Basically, you will have to understand the provisions which are given under the Industrial Disputes Act and what are the provisions which are given in the Industrial Employment Standing Orders Act and how much power is given to you by the appointment letters which you have issued to the employees who are working in your organization. These are the things. Now, to understand the various provisions, I will go with the provision of layoff, the retrenchment, and the closure as is specified under the Industrial Disputes Act. Now, let us understand Industrial Disputes Act 1947 has been there for a long period of time, and it basically defines what is an industry, who is a workman, who is not included in the definition of workman, how you can effect layoff, how you can effect retrenchment, or how you can effect closure. Definition of industry that includes everything almost, whether it is business, trade, undertaking, service, employment, industrial occupation, or avocation, whatever is there. Who is a workman? Workman is any person who is employed in any industry. Mark my words now, please. In any industry to do any manual, unskilled, skilled, technical, operational, clerical, or supervisory work for hire or reward. Please, please give attention to the word supervisory in the definition of workman, because this will become a most contentious matter when you are going to lay off the people or you are going to take action against the employees who are working in your establishment post the lockdown period. But who are not included in the definition of workmen? They are the people who are working in managerial or administrative capacity, or those people are not covered who are supervisors. They are drawing 10,000 rupees per month and are also performing duties of managerial or administrative nature. Otherwise, they will also fall in the category of workmen. As I said, mark my word there, they will also fall in the category of workmen and they will be treated as such. And so all the provisions which are otherwise applicable to workmen, they will also apply to the supervisory cadre people also. For the benefit of the people who are there, because as I said, post lockdown you will have to undertake many of the actions which are required. One of them would be layoff, and layoff, when it is done on account of various reasons, primarily on the grounds of shortage of coal, power of raw materials, accumulation of stocks, breakdown of machinery, natural calamity, or for any other connected reason. Now, for any other connected reason should have a kind of similarity between the other four reasons which have been given. I repeat, shortage of coal, power of raw materials, accumulation of stocks, breakdown of machinery, natural calamity. These are the four major reasons which have been given. And for the benefit of the participants who are there, the pandemic COVID-19, by a circular of 19th February 2020, the Ministry of Finance has already classified this pandemic as a natural calamity, and therefore it will qualify as a ground for laying off the people from their organization. Now, when do we effect layoff? Layoff, as we are saying that this is a measure which we are going to take in various establishments for the purpose of rationalizing the manpower. Now, layoff is done in a continuous business. It is only a temporary stoppage, and wherever the permission to lay off is to be availed from the government authorities, then in that case, where the permission is obtained and permission is granted by the statutory authorities, then within a reasonable period of time, you have to lay off those people for whom you had gone for the permission part. In the case of layoff, the establishment continues. I repeat, the establishment continues, the business continues. Only the eventuality that takes place is that you ask some of the people not to come on duty for the period when they have been laid off, for which they will be paid 50% of the wages in terms of the Industrial Disputes Act and in terms of the Industrial Employment Standing Orders Act. Now, but prima facie or on its own, the Industrial Disputes Act, while it defines what is a layoff and how it is to be done, or what are the reasons on the basis of which a layoff can be done, please understand the power to lay off is a must. And where do you get the power to lay off the people? That comes either from the appointment letter or from the standing orders, where it has been defined and how it can be done. That process is already given in the Industrial Employment Standing Orders Act. To this, I would add, if the to any organization, Industrial Employment Standing Orders Act and the Industrial Disputes Act is not applicable, in those cases, if the power to lay off is not given in your appointment letter, then even though you may lay off the people, in that eventuality, you will have to pay 100% of wages, not 50% of the wages, because your appointment letter did not have the power to lay off the people in times of need. So this has to be taken care of, and before arriving at a decision to lay off the people, you will have to see what benefit you are deriving by laying off the people or by not laying off the people. So this has to be understood clearly. Now, where do we require the permission to lay off the people? Where less than 50 people are there, then in that case, you will not require the permission from any government authority to lay off the people. But where the people are more than 50, less than 100, that will be governed by the Industrial Employment Standing Orders Act, because, that will be guided by Chapter 5A of Industrial Disputes Act, because there in that case, Chapter 5A becomes applicable. And there it says that if you have more than 50 people, but less than 100 people, there you can lay off the people provided you pay them 50% of the wages. In cases where you are employing more than 100 workmen, in that case, under the provisions of Industrial Disputes Act, you will have to follow the provisions of Chapter 5B, and there you will have to seek the permission from the statutory authorities who are prescribed under the Industrial Disputes Act, that is the Labour Office, which is given whether of state or centre, that as the case may be applicable. The other possibility or the other thing which you can do is retrench the people. When do you retrench the people? Retrenchment takes place when surplus labor is there. Though, of course, the judgments have been there for any reason whatsoever when you are retrenching the people, it is taken as retrenchment. But then we have to understand that retrenchment is when you have surplus labor. You don't have that kind of work available with you and you want to retrench the people. So if you are retrenching the people, you will not only have to pay the retrenchment compensation under Chapter 5B, you will also have to seek permission from the labor authorities for retrenching the people. And in that case, for example, let's say first you lay off the people and then you retrench the people. In that case, what can happen is after 45 days of layoff, if you are going to retrench the people, the amount of compensation which you have paid as layoff compensation, that can be adjusted against the retrenchment compensation, and therefore thereafter you can retrench the people. But there may be certain cases where you have to finally close down the establishment, and there also Chapter 5B comes into picture, and you will have to seek the permission of the labor authorities to close down the establishment where you are employing more than 100 workmen. Less than that, you may close down, you will have to give the notice, you will have to do all other things which are given under your Industrial Employment Standing Orders Act, or you will have to follow the provisions of the appointment letters issued to the respective workman or the employee who is working in your establishment. So these are the provisions of the Industrial Disputes Act which you will have to take care of post lockdown when you are going to think in terms of laying off, retrenching the people, or closing down the establishment as such. Possibly, this is a painful exercise. What we are trying to do or what we are trying to suggest is a painful exercise. But then lockdown has been painful not only for the employees but also for the employers as well as the government as well as the regulatory authorities who are trying their best to see that the things come to normal and not much of difficulty is posed not only to the employers as well as to the employees. So this is how it is. But then I go back to it. The the lockdown period of 29th the lockdown period which otherwise commenced from 25th of March, that has been extended on 14th of April for a period of 19 days from 15th April to 19th 3rd of May. Now, even when the circulars have been issued by Ministry of Home Affairs on 14th of April and 15th of April, please understand that they have tried to give a consolidated guideline from the period of 24th of March onwards, and they have been issuing various circulars which say what are the terms and conditions that shall prevail under the period of lockdown. Though the circular of 29th of March 2020, why I am referring to circular of 29th March 2020 is that circular alone said that for the period of lockdown you will have to pay the wages even if the establishment is not working. Now, when the consolidated guidelines have been brought into picture, the circular of 29th March, of course, has not been referred to in that circular, but then the guidelines which have been prescribed on 14th of April and 15th of April by the Ministry of Home Affairs, that says all the guidelines that have been issued for the purpose of lockdown shall continue, and therefore we presume, I am using the word, that the direction which was given as regards the payment of wages, as regards the provision of accommodation for the migrant labor, as regards the landlords being asked not to ask the tenants to vacate the premises and the students to vacate the premises, that shall continue for the period of lockdown. But then this is a contentious matter because even the the guidelines that have been issued under Disaster Management Act, under Section 71, the provision has been made that the people who are adversely affected or those who feel that the guidelines which have been issued by the government are beyond law, they will have to approach the concerned High Court or the Supreme Court for getting the redressal. I repeat, you will have to approach only the Supreme Court or the High Court under the Disaster Management Act to get any kind of relief against the notifications, against the directions, against the advisories that has been issued by the central government or the state government under the provisions of Disaster Management Act or Epidemic Diseases Act 1897. Am I clear up to here? Kapilji, please
Mr.
ask.
Kedia, yeah. Mr. Kedia, in this, I would like to enlighten our fellow members that
हाँ जी,
on 14th of April, there is a special leave petition filed by Nagrika Exports Limited. We have the copy with us, so we can share with our members. It is disputing the orders issued by Ministry of Home Affairs on 29th March and subsequent, you can say, announcements by the government for the payment of wages. So it is a leave petition which has been filed very recently. So we will definitely update our fellow members on the hearings and what the take of the Supreme Court on the same. Because as per the Disaster Management Act, under Section 71, there is a provision which says that anybody who is aggrieved with the order of any authority under the act or under any other act, they can go to the Supreme Court for the relief. So I believe under this act only, under this section only, they have filed the petition. So we will update
yes,
the members as and when the hearing occurs. Thank you.
correct. The petition which has been filed by Nagrika Exports, we have gone through that petition carefully, and I find they have taken the various provisions which have been invoked by the central government and the various state governments under the Disaster Management Act as well as Epidemic Diseases Act, and they have clearly said, of course, that is the that is the thinking which has been going on in the entire business community as to where from they are going to pay the wages if they don't have the revenues in hand, they don't have the orders in hand, the business lines have stopped working, and there is no production, there is no extension of services which is being given to the clients. Therefore, no money when it is there is no inflow of the money. How the outflow of money can take place? That is a big difficulty. And in any case, that also um, you know. Uh, supersedes the universal principle of no work, no pay, which has been given legal recognition in various Supreme Court judgments, which has been there. When there is no work, there is no pay. So why should the employers and the business houses be asked to pay the wages for the period when the employees are not being asked to work? But then there will be various other reasons where there would be various other factors that would prevail in the minds of the Supreme Court judges also before delivering a judgment. But then whatever judgment comes will be applicable to everyone, and so we'll have to await the consequences of what Supreme Court judgment is and how they go along with the situation that has been created by this pandemic. Am I clear, sir? Hello.
Right,
Am I
right.
clear? Yeah.
Yeah,
So I think we have covered most of the part as far as the content and context of the provisions of DMA Epidemic Diseases Act is concerned. What are the provisions on Industrial Disputes Act, Industrial Employment Standing Orders Act, and the respective appointment letters are concerned? We have covered that. So we come to the most important part. I am starting with the frequently asked questions because I want to leave the last 20 minutes for the questions that may emanate from the participants suo moto.
Mr. Kedia,
Okay.
sorry to interrupt
Yeah.
you. Can
Yeah.
we enlighten our members on the difference between layoff and retrenchment also, so
Yeah,
that
sure. Yeah,
yeah,
yeah.
please, please go ahead.
As I said, see, whether it is retrenchment or it is layoff, it is a phenomena which is getting guided by the scales of business. As we know, we are going to get reduced business. We are going to not have that many orders as to warrant that we operate on full capacity. So what do we do in layoff? In layoff, what happens is we lay off certain people from the services, saying that you are not required to come for a particular period of time, during which period layoff compensation would be paid, whether 100%, 50%, or whatever it is, that will depend on the individual circumstances. But then you will have to pay the layoff compensation. This will be of a temporary nature. Layoff cannot continue for a long period of time. After all the owners of the businesses, they only feel that this is a temporary phenomena, and therefore the business will limp back to its original form, and there you will require the employees to come back and perform their duties. In the case of retrenchment, what happens is you don't find that the business is going to come back to a normal very soon. And in that eventuality, you feel that it will be for a longer period of time in comparison to layoff, and you don't require those workmen. They are surplus in nature. They would not be required. They will be adding to your costs as far as the services or the product is concerned, and therefore you retrench. What we mean by retrench is you terminate their services, you ask them to go away from the organization, and therefore you will have to pay the retrenchment compensation, the notice period, and wherever gratuity is applicable and payable, that will also have to be paid. But then this retrenchment will be, as per Industrial Disputes Act, to qualify for the payment of retrenchment compensation, you will have to see that they have completed continuous service of 240 days as defined under the Industrial Disputes Act. If they have not completed 240 days, they will not be eligible for the retrenchment compensation, and therefore they can be shunted out without any compensation being paid to them. So, and then I'll take this opportunity of saying, when you are retrenching the people, there may be a position where you have to close down the establishment. In the eventuality of closing down the establishment, the entire establishment or the business itself is closed down, and that will affect, the closure will also affect retrenchment of all the people who are working for you. Therefore, the establishment will stand closed. The employer-employee relationship of all the employees will come to an end, and the organization will stand closed in terms of whether the permission was granted or it was not granted. If it is an illegal closure, possibly you will have to face the penal consequences by going to the court, which may be filed by the employees union or maybe the statutory authorities like the labor department. So that will be there. So we have to understand these differences between layoff, retrenchment, and closure. So am I clear now, Kapilji?
Yes, Kedia ji. Thank you.
Okay. So we go ahead to the frequently asked questions. That would be better because that will clarify various things which we have discussed up till now, and that will give an idea what exactly is to be done in the day-to-day circumstances. So I come to the first one. The first question is, are wages to be paid if my office or factory is under shutdown due to COVID-19 and employees are barred from coming to work? Answer is, there is no provision for deduction as of now. We have already said the 29th March circular has to be read along with the circulars that have been issued on 14th of April and 15th of April. And therefore, current government advisory is that there will be no deduction against the wages that are payable, and they will have to be paid on due dates. For the month of March, it should have been paid by 7th of April, and for the month of April, it should be paid by 7th of May. Can establishment retrench during lockdown? No. Answer is a big no. As per the current government circulars which are enforced, no employee can be terminated during lockdown. Can establishment retrench post lockdown? Yes, you can do that depending on the strength of the workmen, whether you require the permission from statutory authorities or not. You can retrench the people after paying the retrenchment compensation, the notice period, and whatever gratuity is falling due. What about paying the contribution under PF and ESIC? mandatory to pay unless it has been extended or benefits are provided by government as per announcements. That we have already discussed in the first two slides. What
Mr.
would be
Kedia,
the strictly?
yeah,
Yeah.
Mr. Kedia, sorry to interrupt you. Can you also highlight something about the sickness benefit under ESI?
No,
How
that I will
it
do.
can we claim? Okay,
Yeah, that I will do because let me complete with this so that people who are
okay,
having other questions they can call upon with the other questions also.
right.
So what about paying the contribution under PF and ESIC? It is mandated to pay. Nothing has been curtailed. Only thing is period to pay the contribution has been extended as was indicated in the initial slides. What would be the sick leave policy for infected employees? Only two states as of now, that is Karnataka and Uttar Pradesh. They have specifically, I am repeating the word, they have specifically passed orders stating that all COVID 19 infected employees are required to be provided 28 days of additional paid sick leave over and above their existing leave entitlement. So after having done that, whether they would be required to, give their fitness certificate, etc. Yes, they will be required to give their fitness certificate, and employers may potentially be additionally liable for medical expenses also, because this may be taken as as an accident arising out of the employment, and therefore not only ESI would be liable to pay the sickness benefit, cash benefit, etc., etc. Even the employers, for the people who are not covered under ESI, they may be additionally liable for the medical expenses that may be incurred by the employees having got if, affected by COVID-19. Whether the time off being given right now can be considered as paid leave, and if no leave is available, to be considered as leave on loss of pay. Again, the answer is a big no. As per the current advisory, as per the current government circulars, you cannot do it. Otherwise, also let me clarify. The grant of leave is a matter of right for the employer. But when is he going to avail it? That the employer cannot thrust upon the employees that you will have to take this leave or you will have to go on leave for this particular period. So this cannot be done. Can employees be laid off as the business is staring at a slowdown and reduction in revenue is drastic beyond manageable limits? I have already said it can be done post lockdown. During the period of lockdown, it cannot be done. What about payment of stipend to apprentices? They will have to be paid. Government will reimburse wherever it is applicable, and that amount will be given to the respective employers by the government in due course of time. Can employers
For the
ask
members,
employees?
Mr. Kedia, just a second.
Yeah, yeah,
Since the apprentice word is written, so I would
yeah,
like to add on that this
yeah.
apprentice is for the apprentice they are which are being hired under the Apprentices Ship Act. This is not
Apprenticeship
under
Act
the chartered
1961.
accountants. Right. So this
Yes.
is these
Uh,
the apprentices are not for the apprentices hired under the Institute of Chartered Accountants of India Act. So,
yes, yes.
there will be no reimbursement of a stipend for a CA firm because we are hiring under a different act. So, this question and answer is mainly for the industry. Thank you.
Correct. 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 Can employers ask employees for medical tests and reports? Yes. Employers may require employees who are coming into work or even working from home to undergo medical tests or temperature screenings with the consent of the employee. Employers may also require employees to report any medical symptoms to the employer. If an employee is found to be infected with COVID 19, then the employer may make it mandatory to disclose to all the people within the organization who may have encountered the infected employee. These potential employees would also need to be intimated. See, what happens is because people are asymptomatic initially, so it may be possible that an asymptomatic employee ultimately may turn out to be COVID positive, and so people who would have been in touch with them, they also need to be notified that they were in contact with the person who has turned out to be corona positive, and they need to be quarantined, and necessary steps should be taken for their isolation and medical treatment. Is MHA order overriding all other statutes in India? Yes. But we have already said there is power given in Disaster Management Act to appeal against the order which can be resorted to by the aggrieved person. And as rightly pointed out by Kapil Goyal earlier, as of now, as per the information available with us, there is only one petition that has been filed in the Supreme Court, that is by Nagrika Exports Limited, a company which is based in Bombay and is in the business of, I think, export. That is the only company who have gone ahead filing with a petition in the Supreme Court. These bodies which are there, that is the employers' bodies, PhD CCI or FICCI or SOCHM or even PhD Chamber of Commerce of Delhi, etc., etc. I don't think they have moved any of the courts going against the provisions of the Disaster Management Act or the Epidemic Diseases Act, under which the government of NCT of Delhi had also issued a direction.
One request from all the members. I have just got a request to speak. You have the option for a full screen view of the PPT. So, in case any of the member is not able to see the entire PPT, it's a request to click on the full screen option to see the entire PPT. Thank you.
We would be sharing the PPT with them, na?
Yes, yes, but
Hello.
as of now, they have the option.
Yeah, sure, sure. So I come to the next question: treatment of employees having last working day during lockdown. The employees whose last working day during the period of lockdown shall stand relieved on the due date and shall be paid wages till such day in terms of the employment contract. What would be the treatment of employees who applied leaves for period under lockdown? It will depend on the nature of the industry, whether work from home was resorted to, whether leave duration is coterminous with the lockdown period, and so on and so forth. So this will have to be understood in terms of the peculiar circumstances of the organization concerned. Treatment of employee who was absent on the penultimate day of lockdown. I will explain it like this: where the lockdown, because the lockdown in the entire country came into force on 25th of March, let us assume there was an employee who was absent on 23rd of March. He did not turn even on 24th of March. The absence which was there was without any information to the management. He did not even tender subsequent explanation for his absence and remains absent, therefore, for the entire period of lockdown. In that case, please do not pay any wages because he is not entitled. His absence has remained unregularized for the period penultimate to the period of lockdown that came into effect. Treatment of the absence period for workmen affected or who are supposed to be affected by COVID-19, then such employees are to be kept in isolation, shall be provided paid leave on production of medical certificate at the time of resuming duty. Next question is, if an employer pays for the lockdown period and employee or oblique worker extends his leave beyond the lockdown period, then what should an organization do? See, once the lockdown period is over, the organizations then will take steps under the applicable statutes and contracts to deal with the absence. These could range from the deduction in leave entitlement or leave without pay or other remedies as per the organizational policies. But despite notice, if an employee refuses to join work during the period of lockdown, then steps can be taken, whether by way of disciplinary action or by way of what has been provided under the Industrial Employment Standing Orders Act or Industrial Disputes Act. And for the non-workmen, you can consider the terms and conditions of the appointment letter or the employment contract which has been entered into between the employer and the employee. But we would suggest, given the present scenario, it will be advisable for the employer not to deduct wages in the event an employee is suffering from COVID-19. Can the employer defer or avoid payment of bonuses, raises to employees for the current year? In case of bonus, the bonus will have to be paid within 8 months from the end of the financial year. Therefore, there will be no avoidance on that account. But yes, the increments, other raises which you may be giving to the employees per year or on an yearly basis or on half yearly basis, that of course you can avoid. That is within your powers. It is not necessary that you should pay that. Next is where those organizations who are engaging contractors for getting the work done, If the principal employer doesn't pay to the contractor, then who is going to be accountable in terms of the directions which have been given by the Ministry of Home Affairs by virtue of 29th March circular? Who is going to pay or who is not going to pay, and in that eventuality, who is liable? So the answer is both are liable. The contractor is liable because he was the employer for his workmen, and principal employer is liable because under the Contract Labor Regulation and Abolition Act, he has the responsibility of ensuring that the wages are paid to the contract workman during his presence, and if not paid, then the principal employer becomes liable. So even otherwise, he is liable because he has not paid to his contractor, whereby the contractor has not paid to his contract workman. So both are liable. The next question is, the contract comes to an end during the intervening period of lockdown, whether liable to pay wages for the entire lockdown period. There is no liability to pay wages because the contract itself has come to an end. Your work was supposed to end by that period, therefore nothing is payable. Whether any extra payment is to be made to those who come to place of work vis-a-vis who work from home. There may be certain organizations where you have asked some of the people to stay at home because they can't come to the workplace and work, and there may be certain other cases where you have asked the employees to work from home. In that case, what will happen is, you don't have to make any extra payment to the people who are working from home. They are otherwise supposed to work, whether they are working at the workplace or they are working from home. They are being paid salary. Therefore, there is nothing that is extra which is required to be paid. Whether overtime is payable in cases of work from home, no. Normally it will not be, because when you are working from home, if you are working for extra hours, please note, whenever overtime work is resorted to, it should have the consent of the supervisor, manager, or the owner of the establishment. Without the consent, the overtime work cannot be executed. That meaning thereby, the work is performed on an overtime basis only if the consent is there from the employer or from the management or from the supervisor. If he has not consented for it, the work that should have been performed by you in 8 hours, you are doing it in 10 hours. You cannot claim overtime for 2 hours. That is not required, and that is not payable. The last question would be, any additional wages to be paid for the holidays, that is the festival holidays, which may be falling during this period to people who work from home. See, otherwise you would not be paying. But if you are asking certain people to work from home, even on the days when there is a festival holidays, in that case, yes, you will have to pay additional wages for the period, because that will be treated as period having worked on overtime, and in that eventuality, the responsibility of paying additional wages to the employees would definitely be there. So these were the various questions which we thought would be there, and keeping these things in view, if ultimately, as we said, the uh, orders are there from the Ministry of Home Affairs, but there may be possibility that you may not have sufficient resources to pay the wages. In that case, what you are going to do? What you will have to do is, you will have to see that all the documentation is complete, all communications are complete. Then you will have to understand what were the legal consequences, and where on account of financial difficulties you are unable to pay, you will have to have adequate justification with you, so that in the time when the prosecution takes place, or the labor office calls for your explanation, or they want you to explain why the wages were not paid, then you will be able to explain it. I repeat, in any case, when the inflow is not there, the outflow of funds also cannot take place, and that will depend on the paying capacity of the employer, whether they want to pay the wages or they don't want to pay the wages. Of course, the government directive is that you have to pay the wages, but if you are not paying the wages, then you have to take a call there how you are going to justify your stand, for which your financial papers, financial data, financial equations, they should be well documented, and you should be able to prove it before the court that you did not have the capacity to pay to the employees and the workmen, and therefore the prosecution or the penal action should be dropped against you. This is what is required to be done. You will have to be transparent during this period of lockdown. You will have to see that your documents are in order, and you observe not only the precautions that have been given by the government, whether it is the central government or the state government. You will have to see that you follow the policies which you have laid down even for your day-to-day functioning, so that you can give answers in a transparent manner. I rest my PPT with this. Any questions that are there, they may be taken up now.
So in this slide, I just want to discuss a bit more on the last option, last caption, which says follow industry practices. So, in my opinion, even if you are following the industry practice of not paying to the employees for the month of April, because I have heard, there are many news which are coming from either Haryana or from UP, that industry have consolidated among themselves, they and the whole associations, they are saying to the government that we are not going to pay the April salary because we don't have funds. So even if your company or your establishment is following that decision, that doesn't save you from negative actions from the labor office. Am I right, Mr. Kedia?
Yes, yes, definitely.
So
So
we need to
these
be
are the various precautions that need to be taken. But what I am saying is, you need to be transparent whenever you have to, face the labor authorities or the other statutory authorities. Definitely, because the penal action will have to be contested in the court of law. So if you are transparent, you have documented each and everything, you will be able to prove it, and therefore you may not be loaded with the liability there.
sure, sure. So before we move to the question and answer sessions, can you please highlight something to our members on ESI sickness benefits
Yes.
on which contention is
See,
going on? Yeah,
yeah, there is some kind of WhatsApp message that has been going on, and that has been floating across, that ESI. I will explain it this way. The gist of that WhatsApp communication that has been floating indicates that the employee will go to the ESI dispensary. He will say that he is unable to go to his place of work, and therefore he should be issued a medical certificate, on the basis of which he will be able to remain absent from the place of work, and he will get the sickness benefit, which may amount to up to 91 days of benefits during two consecutive benefit periods. So to that extent, that is thereby meaning to say that the ESI dispensary or the ESI hospital where the employee has gone, saying that he is unable to go to the place of work on account of COVID-19. Of course, that may not be there. He may or he may not be suffering from COVID-19. If he is suffering, definitely he will be issued a medical certificate, or he will be referred to a hospital. It is in respect of those employees who are not sick but are unable to report at the place of work because the place of work is not functional. In those cases, the WhatsApp message suggests that the person can go to the ESI dispensary, ask for a medical certificate saying that he, on account of the apprehension that he may suffer from COVID-19, he is unable to go to the place of work, and therefore please issue a medical certificate which will make him eligible to get the benefits under ESI Act to the extent of 91 days. This is not being done by any of the ESI dispensaries. I am making it very clear. No ESI dispensary, no ESI hospital is issuing a medical certificate to any workman who is not otherwise sick and who says or who contends that he is unable to go to the place of work because he is apprehensive of getting affected by COVID-19, and he wishes to avoid going to the place of work. Am I clear here?
yes, yes, Mr. Kedia, thank you.
Yes.
So I
So
have got few questions. Yeah,
this two page WhatsApp message that has been circulating around has no value. Even otherwise, if people would go through the this two-page note which is floating around, see, it says the word ESI should. Had it been shall, then it should have been shall. Should is someone should do it. If he is not doing it, that is something different. Okay.
and also I would like to add in Mr. Kedia's view that nowadays WhatsApp viral messages are coming to all of us in a big way. and it should be our duty, first of all, before we circulate it to anybody else. It should be our duty to check from the government portals or from a consultant or from lawyers on the you can say authenticity of such messages. Then only we should forward it. Otherwise, nowadays government is taking stern actions against somebody who is making these messages viral, and they might issue notices to chartered accountants also if we are not careful enough to circulate any such message to anybody, even to our clients or to the public masses in general. So please do verify on all such messages. And you will not believe there are many government signed orders which are fake, as we have seen earlier at the time of income tax dates extension or MCA dates extension, that sometimes we get to know of date extension emails. So we should, at this time, we should be extra cautious, because every industry, everybody is in pain. So this is our moral duty as well as professional duty. So, Mr. Kedia, now I would like to move to the question and answer sessions. I have got few
Yes.
questions to me,
Okay.
so I will ask on behalf of the members to you.
Okay. Go ahead.
Yeah. So the first question: does provisions of Industrial Disputes Act also apply to a trader having less than 50 employees or workers? Is it mandatory
No, that
for
would
the owner? Yeah, is it mandatory for the owner to pay the salary for the lockdown period? Please clarify.
no. As far as a trader is concerned, as I said, if it is less than 50 people, otherwise also it is not applicable. So the Industrial Disputes Act for the trader, where you are employing less than 50, it may not be applicable. But then, uh, even in that case, I think the extension of Industrial Employment Standing Orders Act, which has been done to Haryana Shops and Commercial Establishment Act, that also is specifying 50 or more people. Therefore, Industrial Employment Standing Orders Act also would not be applicable, and because they will not fall in that category. In that case, what they will have to do, the question whether the payment of wages has to be made or not, the circular which has been issued by MHA, that does not specify whether the number of workmen has to be 50, more than 50, more than 10, more than 5, or so on and so forth. They have said all establishments, and they have classified there all establishments which are there, they will have to pay the wages.
Okay. Thank you, Mr. Kedia. Now I will move to the second question. What happens if the employees of essential services do not attend to office? Is 29th March notification applicable in those cases?
In the case of essential services, nothing changes for them. The people have to report for duty. It And if they are not reporting for duty, in terms of the discipline, in terms of the service rules or the conduct rules or the discipline and appeal rules, whatever is applicable to the establishment concerned, they have to initiate disciplinary action against him.
Okay. The third question is on our labor was not fixed before lockdown. That is, we called as and when required. Then
Yeah.
how we calculate the labor cost for lockdown period?
Then why do you have to calculate the labor cost for the lockdown period? See, I said, see, if I have understood the question properly, let us say you have been calling the people on and off on the basis of exigencies of the business, and you called someone on for a particular day on 24th. That's all. The daily wager who came to you on 24th of March, he came only for one day. After the office hours or after the business hours were over, his employment ended. Therefore, nothing is payable for the lockdown period for such daily wages.
Right. So the question four: can employer deduct salary by taking consent of employees during lockdown period?
I would not advise people to do so. But yes, what happens is, uh, there is a saying in the law, legal jurisprudence. It is saying that if something has been prescribed under law, by virtue of agreement between two people, you cannot enter into an agreement which supersedes the law. Therefore, when the directives have been issued under the Disaster Management Act, which also has the backing of law, there I would not suggest that you take the consent of the people of foregoing the wages or doing something like this, and at least not on paper. That may create difficulty. But if you can have a understanding with all the people, and they also feel that in the interest of the organization it can be done, you may resort to. I have no problem, but I would recommend not doing it.
Absolutely. Absolutely. Because the employees may or may not consent afterwards at the time of the labor inspection or
Yeah,
sometimes. And there
you
could
never
be a.
know. Subsequently, they may
Absolutely.
say that we were forced.
Forced to give the
Subsequently,
consent on. Right.
they may say coercion was exercised on us by the employer, and therefore we had no other opportunity but to sign the paper. So please try to
Right.
avoid. As far as lockdown period is concerned, please try to avoid this.
So actually, my opinion would also be that during this time we should pay the entire salary, and whatever we have to do, readjust the salaries, layoff, retrenchment, we should do in the post-lockdown period when the things
Post
will open.
lockdown period. Yes, yes,
Yeah. So
yes.
we can offset our the cost which we are paying this time with the post-lockdown period.
Correct.
Yeah. So the next question goes: our labor is contractual labor, and after lockdown we reduce the labor, then we have to pay for the current labor, or as per the labor we were taken before lockdown, we produced essential items.
Now, can you repeat the question? I didn't get it.
I think it is on the screen. Are you able to see it?
Now, yes. Our labor is
Yeah.
contractual labor, and after lockdown, after lockdown, if you are reducing the labor, then you see the liability to pay the wages is only for the lockdown period. I will explain it this way. Let us assume the lockdown period finally comes to an end on 3rd of May. 5th of May, you are reducing the labor by virtue of you not having work or you not having the orders, and you don't want that many people. You have paid wages up to 3rd of May. That is the lockdown period. From 5th of May, it is business as usual. If you want only 20 contract workers instead of 40, it is your choice. We have nothing to do with that. No one has anything to do with that. It will depend on the simple business semantics and business matrix that you want to have 40 people or 20 people.
Absolutely. Absolutely. Next question is: can deduction be made for managerial or administrative staff?
In respect of lockdown period, no. Post lockdown, you
And
can rework
yeah.
the entire package structure. You can do anything with the managerial and the administrative staff. But during the lockdown period, the circular of the Ministry of Home Affairs uses the word workers. And workers, for that matter, if you go by the definition of Factories Act, everyone is a worker. But then the circulars which have been issued by Ministry of Home Affairs, that does not pay any heed to any of the labor laws. For example, whether it is Payment of Wages Act or Minimum Wages Act, or it is the Factories Act or Industrial Employment Standing Orders Act, or even the Industrial Disputes Act. Industrial Disputes Act, you have the definition of workman. Factories Act, you have the definition of worker. Payment of Wages Act, you have the definition of employee, so on and so forth. So the word worker that has been used by Ministry of Home Affairs in their circular will comprise of everyone, whether it is managerial, administrative, supervisory, or the pure blue collar worker as we call in our parlance.
Next question: can we defer salary or pay salary in parts, in installments, with the consent of employees?
See, this question was answered earlier also. See, even if you are taking the consent, as I said, any agreement which is superseding the law, even if the two parties there are there, उन्होंने अपना बात कर लिया, ठीक है साहब हम ऐसे ऐसे कर लेते हैं, and that is against the provisions of the law, that will not stand. उसमें से कौन सी पार्टी कब बदल के आपको कुछ कर देगी, then what you will do? Even otherwise, that would be an illegal agreement, and illegal agreement will not survive the day. So that should not be done for the period of lockdown. I would not suggest this should be done. Only
And
after
yeah,
post lockdown, you may try to work out. See, जितनी डिफिकल्टीज एम्प्लॉयर्स को है साहब, उतनी ही डिफिकल्टी एम्प्लॉयज को भी है. एम्प्लॉयर्स पैसा नहीं दे पाएंगे, सैलरीज का, वेजेस का, बात सही है. एम्प्लॉयज भी ऐसा नहीं है कि हर धर्म एक अपना लेंगे कि साहब नहीं हमको तो पूरा ही चाहिए और हम तो नहीं तो हम ऐसा करेंगे. उनको भी पता है डिफिकल्टी एम्प्लॉयर के पास भी है, जो ऑर्गेनाइजेशन है उसके पास भी है, एंड देयरफॉर दे विल डेफिनेटली ट्राई टू वर्क आउट अ वे सो दैट उनका एम्प्लॉयमेंट भी कंटिन्यू कर जाए, एम्प्लॉयर को भी डिफिकल्टी ना हो, उनका घर भी चल जाए. ये सारे रीजन विन विन सिचुएशन के हिसाब से आपको देखने ही पड़ेंगे, और इसमें इसके अलावा कोई चारा नहीं होगा.
और इसमें मैं एक चीज और ऐड करना चाहूंगा कि जो अभी पीएफ का ऑर्डर आया है फॉर एक्सटेंशन ऑफ द पेमेंट कंट्रीब्यूशन डेट बाय 1 मंथ, उसमें स्पेसिफिकली ये लिखा हुआ है कि जिसने मार्च की सैलरी पे कर दी है केवल उसी को एक्सटेंशन मिलेगा. जिसने अगर सैलरी पे नहीं करी है उसके लिए डेट 15 अप्रैल ही रहेगी.
हाँ जी, उसमें वो एक लाइन बहुत बीच में डाला हुआ है कि those who have already paid, those who have already disbursed the March salary, they have used the word disbursed. Disbursed का मतलब है कि पेमेंट वाकई में हो गया है.
राइट. नेक्स्ट क्वेश्चन, कैन वी मेक चेंजेस इन एम्प्लॉयमेंट कॉन्ट्रैक्ट एज नोटिस पे डेज?
You cannot do it. You cannot do.
We cannot do. Right. Next question. Does the act specify any period beyond which layoff cannot be done? That is maximum number of days for which layoff can be done by any organization.
नो सर, ये मैंने बीच में एक्सप्लेन भी किया था. इंडस्ट्रियल डिस्प्यूट्स एक्ट में भी ले ऑफ का कोई पीरियड अदरवाइज स्पेसिफाइड नहीं है. उन्होंने ये कहा है कि जब रिट्रेंचमेंट करने लगे, अगर 45 डेज का ले ऑफ हो गया और उसके बाद आप रिट्रेंचमेंट करने का कोशिश करेंगे तो यू कैन डू दैट रिट्रेंचमेंट वुड बी एक्सेप्टेबल. लेकिन ले ऑफ का ऐसे पीरियड नहीं है. लेकिन लेट अस अंडरस्टैंड, ले ऑफ हम करते क्यों हैं? ले ऑफ इज डन ओनली टू मीट द टेम्परेरी एक्सीजेंसीज विच आर देयर. अब ज़्यादा से ज़्यादा कोशिश यही करते हैं कि 30 दिन की होगी, 40 दिन की होगी, इससे ज़्यादा तो होना नहीं चाहिए. और अगर आपको इनिशियली ही ऐसा लगता है कि नहीं साहब ले ऑफ करने से काम नहीं चलेगा, देन व्हाई एट ऑल ले ऑफ द पीपल? आप सीधा रिट्रेंचमेंट के लिए करो ना.
Right. Next question. Would a CA office in Haryana be covered by ID Act? Is there a difference if employees are 8 or 25 or more than, let's say, 50?
No, see, otherwise देखिए, ऐसा स्पेसिफिकली कह के कि सीए ऑफिस हरियाणा में कवर होगा कि नहीं होगा आईडी एक्ट में, वो डिफिकल्ट होगा. बट इफ यू आर आस्किंग फॉर द पर्पस ऑफ ले ऑफ और रिट्रेंचमेंट, तो 25 अगर है तो वो तो वैसे ही एप्लीकेबल नहीं होगा, क्योंकि उसमें
अगर 50 से ज्यादा हो तो
जो चैप्टर 5A और चैप्टर 5B वो तभी लगेंगे अगर आपके 50 एम्प्लॉय से ज़्यादा होंगे या 100 एम्प्लॉय से ज़्यादा होंगे. तो आईडी एक्ट तो वैसे ही लागू नहीं होगा फॉर द पर्पस ऑफ ले ऑफ एंड रिट्रेंचमेंट.
राइट. बट अगर 50 से ज्यादा होंगे तो सीए ऑफिस इज आल्सो कवर्ड.
It will get covered because see they have specified. इंडस्ट्री का जो डेफिनेशन है उसमें कहा जी, वो उन्होंने बहुत सारी चीजें बताई है. बिजनेस विल इंक्लूड दिस, इंडस्ट्री विल इंक्लूड दिस, देयरफॉर इट कैन बी देयर. अब ऐसा तो देखिए उसमें क्या है, बहुत सारी चीज़ों में कई जगह डिफरेंट हाई कोर्ट्स डिफरेंट काइंड ऑफ अप्रोच ले लेती हैं. कुछ हाई कोर्ट्स ने टेम्पल को भी इंडस्ट्री मान लिया है, कुछ ने नहीं माना है. तो ये दिस इज अ क्वेश्चन व्हिच कैन नॉट बी आंसर्ड एट दिस स्टेज.
But as far as apprentices are concerned, I believe they will not be covered under the definition.
नहीं, they will not be covered.
They will not be covered.
आपके अप्रेंटिसेस वो दूसरे किस्म के
Yes, it is
अप्रेंटिसेस
covered by the act. Right. So
Yeah.
next question. What would be tax liability treatment in case of deferment of salary payment? Will it be still deductible based on accrual principle? It is a
ये तो आप ही
income
आपने
tax query. It is an income tax query. What would be the tax liability treatment in case of deferment of salary payment? Actually, as far as this question is concerned, if we are following accrual basis, as most of the companies and firms are following, so definitely if we are accruing the salary and the corresponding tax has been deducted under TDS provisions, then it will be a deductible expense, and we can take it under our profit and loss account. Next question: what if labor is a per piece worker?
नहीं नहीं, देखिए, जिसको जिसको हम लोग बोलते हैं कि जो स्टेटस को वो मेंटेन करना है। अगर 24 तारीख को आपको शाम को अगर आपका काम चल रहा था और उसके बाद लॉकडाउन हो गया, तो यू विल हैव टू पे द वेजेस।
But how they can pay? How many pieces they have produced?
नहीं नहीं, मैंने इसीलिए वर्ड स्टेटस को वो इस्तेमाल किया कि जो 24 तारीख को ये थोड़ा वर्कआउट करना पड़ेगा, या तो आपका जो एवरेज बेसिस होगा उसके ऊपर देखना पड़ेगा, और अगर वो नहीं देख सकते तो जो 24 तारीख को हुआ होगा वो दैट विल अप्लाई फॉर द पीरियड ऑफ लॉकडाउन।
Okay, okay, fine. But I believe there is no clear directions, so we will have to
नहीं,
see.
there will be नहीं,
How
they
the-
see these kind of, see, everything you cannot have in black and white, but you will have to have the understanding of what the circular says in of 29th मार्च, या जो 25 तारीख की लॉकडाउन की जो जिस तरीके से किया गया या 14 अप्रैल से किया गया, आपको उसकी एसेंस जो है वो समझनी ही पड़ेगी। उसमें एक तरीके से उन्होंने कहा साहब जो 24 तारीख को जो स्टेटस को वो हो गया एम्प्लॉयमेंट के बारे में, वो वैसा ही रहेगा फॉर द पीरियड ऑफ लॉकडाउन। अगर उसके कॉन्ट्ररी आपका पहले से ही कुछ चल रहा था, फॉर एग्जांपल हमने कहा था, मान लीजिए लॉकडाउन पीरियड के दौरान आपका कॉन्ट्रैक्ट था ही 31 तक का, तो आपका कॉन्ट्रैक्ट 31 तारीख को खत्म हो गया, उससे आपको कुछ नहीं करना है आगे। लेकिन जो चीज आपकी 24 तारीख को चल रही थी उसका स्टेटस को वो मेंटेन रहेगा। अगर वो चीज आप चलाते रहते लॉकडाउन के दौरान, अगर ना भी होता तो भी और लॉकडाउन के बाद भी वो पीरियड अगर चलता रहेगा, तो उस स्टेटस को वो मेंटेन करेंगे और आपको उसका वेजेस का पेमेंट करना होगा।
Right. Next question: factory which are closed during lockdown, will they be entitled to pay salary?
ऑब्वियसली दे हैव
जो
टू पे।
लॉकडाउन से पहले पहले बंद थी, ये
नहीं नहीं, जो
ड्यूरिंग लॉकडाउन
नहीं नहीं
या बिफोर लॉकडाउन?
नहीं नहीं, अगर लॉकडाउन के पहले से बंद थी, अगर लॉकडाउन के पहले से बंद थी तब तो उनका जो टर्म्स एंड कंडीशन उसका समय चालू होगा वही लगेगा। अगर फैक्ट्री लॉकडाउन की वजह से बंद हुई तो ये सर्कुलर एप्लीकेबल हो जाएगा।
Right. Next question: if essential services is an NGO, can we deduct salary for non-attendance during lockdown? And B part:
सर
can we lay off or retrench as part of stringent measure against employee?
सर, I have said status quo will have to be maintained as of 24th March for the period of lockdown. तो लॉकडाउन पीरियड में आप डे ऑफ रिट्रेंच क्लोजर वगैरह वगैरह कुछ नहीं कर पाएंगे। लॉकडाउन इज ए पीरियड एज इफ इट वाज अ पीरियड जीरो वेयर नथिंग कुड हैव बीन डन। द स्टेटस को रिमेन्स, आपको सब कुछ देना है, सब कुछ करना है, सिर्फ आपने काम नहीं करना है उस दौरान।
Right. Next question: how the piece rate workers have to be paid for the lockdown? I think we have answered this question. 16th question: if employer cannot lay off and reduce salary, how the aviation and other companies are announcing pay cut and laying off every day, will there be any action against them?
देखिए ये तो
This is a practical scenario.
नहीं प्रैक्टिकल है। ये स्पाइस जेट, गो एयर वगैरह ने सबने इन्होंने कुछ 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 कर रहे हैं ये लोग, लेकिन बाद में शायद आई डोंट रिमेम्बर किसी एयरलाइन ने बाद में क्लैरिफिकेशन दिया भी है कि नहीं हम इसको बाद में करेंगे, अभी नहीं कर रहे हैं, बाद में करेंगे। सो दिस इज हाउ इट इज गोइंग ऑन एंड सी द पॉइंट बेसिकली इज, अगर मैंने कहा ना कि हर धर्म तो सब एम्प्लॉयज नहीं अपनाएंगे। जब एम्प्लॉयज को मान लीजिए लेट अस से स्पाइस जेट के एम्प्लॉयज है, अब उनको ये समझ में ही आ जाता है कि नहीं हमको आज यहाँ से निकल जाएंगे या कल यहाँ से निकल जाएंगे तो कहीं कुछ मिलेगा ही नहीं, तो क्या करेंगे। तो उसमें उस परिस्थिति में यही है कि सभी लोग कर ले इस चीज़ को, रिडक्शन ऑफ सैलरी कर ले या रिडक्शन ऑफ बेनिफिट्स कर ले, जो भी करना है वो करें। अदरवाइज तो ये पॉसिबल नहीं है एज फार एज दी लॉकडाउन पीरियड इज कंसर्न। लॉकडाउन पीरियड के बाद जो आपको करना है उसमें आईडी एक्ट को फॉलो करिए अगर वो आपको एप्लीकेबल है, और अगर उसमें नंबर ऑफ वर्कमैन डिपेंडिंग ऑन क्या कितनी आपकी स्ट्रेंथ वगैरह है उसमें आपको करना है। आपके यहाँ यूनियंस है, सेक्शन 9A में नोटिस ऑफ चेंज दीजिए, 21 दिन का नोटिस देना पड़ेगा, वहाँ पे भी उसको आपको देखना पड़ेगा। अदरवाइज आप इंडिविजुअल एम्प्लॉयज के साथ बैठ के एक इंडिविजुअल एग्रीमेंट कर लीजिए फॉर रिडक्शन इन सैलरी या वॉट एवर रिडक्शन इन बेनिफिट्स करना है वो आप कर लीजिए। दैट विल बी एन एग्रीमेंट और ए कॉन्ट्रैक्ट बिटवीन टू कंसेंटिंग पार्टीज, उसमें किसी को कोई डिफिकल्टी नहीं आएगी। बट एज फार एज लॉकडाउन पीरियड इज कंसर्न, I am of the opinion something which is being done against the law will not have the validity and therefore it will be futile.
Fine. And in fact, there are so many media news where the companies have taken back their decisions to retrench the people or lay off or salary cuts.
Yes,
So
yes, yes.
already the government authorities are taking actions against such decisions. So we should
हाँ, एक ही
not
कोई
do that.
आई थिंक एक कैपिटल ट्रस्ट करके कोई कंपनी थी ना, शायद उसने भी
Yes, yes.
कुछ रिट्रेंचमेंट किया था, उन्होंने फिर वापस ले लिया, बोल दिया गलती से हमने किया करके।
Absolutely, absolutely. 17th question. We have two more. After this question, two more questions to go. Then we'll close this webinar. End this webinar. Some experts say that complaint for deduction or non-payment can be made to police under the Disaster Management Act. Is it true?
नहीं, देखिए वो तो सारे प्रोविजन उसमें हमने स्पेसिफाई किए हैं, आप उसको पढ़िएगा। लेकिन अल्टीमेटली पुलिस ये नहीं कि सीधा आए और आपको पकड़ के ले जाएंगे, ऐसा नहीं होगा। that will have to be done in consonance with the provisions which have been outlined by the state. अब किस स्टेट में क्या किया गया है, क्या उन्होंने कहा है, who will take the cognizance of the complaints which are arising, that will depend on the state concerned, not in a matter general कि भाई हमने सबको कह दिया और पुलिस के पास जाइए कंप्लेंट कर दीजिए और आपको पुलिस उठा के ले जाएगी, ऐसा नहीं होगा।
Right. 18th question. Would minimum wages suffice for peace worker in lieu as 22nd was Janta curfew, 23rd was not lockdown, 23rd, 24th, and the lockdown started from 25th.
Can you repeat?
Would minimum wages suffice for peace worker in lieu as 22nd was Janta curfew, 23rd, 24th was not lockdown, and lockdown started from 25th of April.
सर अभी हमने कहा कि जो स्टेटस को वो कब मेंटेन करना है, व्हाट वाज देयर ऑन 24th इवनिंग एट द क्लोज ऑफ बिजनेस आवर्स, so that status quo will have to be maintained. Whatever payments were being made till 24th on the same intensity, on the same measurement, you will have to make the payments concerned for the period of lockdown. There cannot be any change. Status quo, I am using the word status quo for the position which was there on 24th at the close of office hours or business hours, that will have to continue for the period of lockdown.
Right. So it is our advice to all professionals to see the records, attendance records, and the payment records as on 24th of March to see the actual occurrences of the business, and based on that, we should advise our client. Last question.
Hadi.
Do we have to pay wages to contractual labor during lockdown, or notification applicable only for permanent labor?
No. See, if this gentleman Amitabh Singhal, if he was in Delhi, I don't know whether they are referring to any establishment in Delhi. Even before this lockdown circular came and the Ministry of Home Affairs gave the directions, there were directions from Arvind Kejriwal which said that everyone has to be paid up to 31st March, which also included the contractual workers. His wording, his circular, his notification includes the word contractual. So, and as I said, that notification was superseded by the notification of Ministry of Home Affairs. There cannot be any difference between the contractual worker or other workers. They will have to be paid. Status quo as of 24th March will have to be maintained, and you will have to make the payments irrespective of the status of the employee concerned.
Right.
If the contract itself has come to an end, comes to an end, let's say between the period of lockdown, as I said, it comes to an end on 31st of March, then it comes to an end. Thereafter, nothing is to be done. Neither they will perform the work, nor you are supposed to pay the wages.
Right. So I believe we have covered almost all the questions and all the problems appearing or facing by our clients or by the CA firms, by professional brothers. So I would like to thank you, Mr. Kedia, and thank you all the branch chairmen and their teams for giving us this wonderful opportunity to discuss our thoughts and the laws with you.
Thank you. Thanks a lot, Kedia ji and Kapil ji, for discussing in detail several practical issues and also solving different problems faced by the members. It would be great for the member throughout the different three branches of ICI. And I would also like to say special thanks to Sharad Paliwal ji, Chairman Agra branch, Shyam Purohit ji, Chairman Vapi branch, for joining us in this webinar. Hoping this webinar is going to be benefit at large to all and each every member. Thank you. Thanks a lot for joining in this webinar.
सर एक चीज बोलना चाहता था एक
Sure,
चीज
sure,
बोलना
sure.
चाहता था
जी
Sure.
सर।
सब लोगों को आप ये पीपीटी जरूर दें और फिर भी अगर कोई क्वेश्चन रह जाता है प्लीज रेफर इट बैक टू अस वी विल डेफिनेटली आंसर दैट
For
Thank you,
sure,
sir.
all the presentation would be there on ICAI.Gurgaon.org's website. And if at all there is any problem that somebody is having, they can always send a mail to gurgaon@ici.org.
And then
Fine.
thank you everyone for joining this webinar.
Thanks a
Thank
lot.
you.
Thank
Thank
you.
you.